Hello, everybody. In this episode, I'll be speaking with Gabriel Weil. Gabriel is an assistant professor at Touro Law, whose research primarily focuses on climate change law and policy. He's recently written about using tort law to address catastrophic risks from AI, which we'll talk about in this episode. For links to what we're discussing, you can check the description of the episode, and you can read the transcript at axrp.net. Well, welcome to Axrp.
Thanks for having me.
Sure. So, I guess we're going to talk about this paper you have. It's called Tort Law as a Tool for Mitigating Catastrophic Risk from Artificial Intelligence. Um, and I think most of my audience won't be from a legal background, and they might stumble over those first two words. Like, what is tort law?
So, torts is the law of basically anytime you do a civil wrong that isn't a breach of contract. So, breach of contract is you promised someone in some legally enforceable way that you would do something, and you didn't do that. You breached the contract. They sue you. Basically, anything else that you're suing a private party for, you're not suing the government. In a civil lawsuit, that is going to be a tort. So most commonly, you think of things like you get in a car accident and you sue the other person. That's a tort. There's also intentional torts like battery. So if I punch you in the face, you can sue me for the harm I did to you. If I trespass on your property, or I, damage personal property, like I break your car window or I key your car, right? Those are trespassory torts. That's called trespass to chattels. Products liability is torts. Medical malpractice is torts. So that's the broad field of law we're talking about.
Gotcha. Great. So yeah, how I guess you have some idea for how we're going to use tort law to mitigate catastrophic risk from artificial intelligence. In a nutshell, what's the idea? How do we do it?
Yeah, so in a nutshell, the idea is that training and deploying these advanced AI systems is a risky activity. It creates risks of what are called externalities in economics jargon, right? So it's harms to people that are not internalized to any economic transaction. They're harms to third parties, right? So OpenAI makes a product, someone buys that product and uses it, but it risks harming someone besides those two parties, right? And therefore, the risk is not reflected in the price of the product, right? And so in principle, holding whoever is responsible for the harm, whoever caused the harm, liable for that, making them pay for the harm they caused, should result in them taking enough precaution to sort of optimally balance the risk and reward, right? So in the same way that in your own life, right, when you're deciding whether to drive to work or walk to work or bike or whatever, right? There's various costs and benefits. You're weighing those. Some of them have financial costs, health benefits, whatever, time costs, and you're able to weigh those risks for yourself. We generally trust that process to work pretty well because you fully internalize the benefits and costs there. You might make some mistakes sometimes, but like your incentives are pretty well aligned. But if there's some sort of externality to what you're doing, so you driving to work creates pollution, right? That's most of the harms of that are felt by other people. Then we might need some legal response to account for that. And so tort law, works well for that when we have a concentrated harm. So for pollution, it wouldn't work so well necessarily for everyone to sue everyone that's harmed by your pollution to sue you. Maybe want some other sort of policy tool like a tax on gasoline or on pollution to align your incentives, right? But if you hit someone with your car, right, and if there's a risk that when you take that trip you're going to hit someone, making you pay for the harm you cause works pretty well to align your incentives to make sure that you don't take the trip if it's not necessary, and you drive with appropriate precaution. You don't text while you're driving. You don't speed too much, right? Now, our existing tort system might not do that perfectly, but in theory, the prospect of liability should make you exercise the right amount of precaution. So that's basically what I want companies that are building and deploying this AI system to do, is to have the incentive to exercise the right amount of precaution. I don't think our current tort system necessarily does that, but I think it can with some tweaks.
Gotcha. So to summarize, it sounds like basically the fear is if you're an AI company, there's some risk you destroy the world. And that's like much worse for the world than it is for you. So you're just going to be like, you're just going to be more relaxed about that risk than you would be if you like really felt the responsibility. If you really like had the, had we're internalizing just how bad it would be if the world got destroyed, or some other sort of catastrophic risk.
So in the limit,
Um,
that's definitely part of what I'm worried about. But I think even for less catastrophic scenarios, there's harms that wouldn't necessarily be internalized by these companies. But yes, in the limit, I think it's definitely true. Now, obviously, if you destroy the world, you kill yourself too. So that's like bad for you. But
yeah,
it's not as bad. You don't feel that as much as killing 8 billion people and all future civilization, right? And so yeah, I think you want the law to sort of make them feel that.
right. So it seems like the obvious difficulty here is that if you have, like, if you suppose you literally destroy the world, right? It's sort of too late
Mm-hmm.
to sue,
Yeah.
right? And this is sort of the first pass difficulty with like some sort of liability scheme. So how how do we deal with that?
Okay, so yes, it is true that there are certain class of harms of which existential harms are a subset, that are what I would call practically non-compensable, right? So you can't actually bring a lawsuit or you can't collect a judgment for it. So I think that includes extinction risks. It also includes risk of harms that would be sufficiently disruptive that the legal system would no longer be functioning. And it also includes risks short of that would just be financially uninsurable. Right? So if you
Hmm.
kill 1 million people, the damage award is going to be so large that you're not going to be able to pay that out. That no plausible insurance policy is going to cover that, and so it would put your company into bankruptcy, and most of that damage is not going to be recoverable. And so the normal type of damages that we use in tort lawsuits, which are called compensatory damages designed to make the plaintiff whole, to make them, in theory, indifferent between having suffered the injury and getting this pile of money or having it never happened. Those aren't going to work to get at those risks. We need some other tool. And so the tool that I propose are what are called punitive damages. So these would be damages over and above the harm suffered by the plaintiff in a particular case, that we're assigning because there was a risk that things went much worse, right? So the system does some practically compensable harm, but it does it in a way that it looks like it could have gone a lot worse. Say there was a 1 in 10,000 chance of killing 1 million people and a 1 in 1,000,000 chance of causing human extinction, right? Then you would want to sort of figure out what the expected value of that harm is, the probability of the harm times the magnitude, and say, well, we're going to pull forward that sort of counterfactual liability from the risk that you took but wasn't realized, and allocate it across the practically compensable cases.
Gotcha. So the way I understand the policy is roughly like, we're going to say that when you have some sort of AI harm, if it's the kind of harm that's like really closely related to these sorts of harms that I couldn't sue you for, like extinction, like some sort of catastrophe that would super disrupt the legal system, or just a judgment that's like too big to collect on, then basically like the punitive damages are going to say like, okay, how, like, what types of harms are that related to, like how similar is this to those harms, how much would like dealing with the problem that you actually caused fix those harms, and basically the punitive damages are going to reflect those factors roughly.
Right. So I think we care about really two things. How much uninsurable risk or not practically non-compensable harm risk was generated by deploying the specific system that you deployed in the way you did. And then we care about this specific harm. If you had a strong incentive to avoid this harm, and you took costly measures to prevent it or reduce its likelihood or severity, to what extent would that tend to mitigate the uninsurable risks? And the more that's true, the more punitive damages we want to load onto those types of cases.
Right. Gotcha. This is a bit of a tangent, but you mentioned that like, at some level of harm, like there's no reasonable, you're not going to have the money to pay off, to pay the damages for this harm. Even like getting an insurance policy, no insurance company would be able to pay out. How much harm is that? Like how much yeah, what are the limits of just like making people buy liability insurance for this kind of thing?
So my understanding is that current insurance policies tend to top out around $10 million. In the
Okay.
paper, I use a much higher threshold for insurable. I use $1 trillion. I think we would want to sort of push the limits of what's insurable to really find out. But I think that's a sort of open question that that needs to be explored before this is fully ready to implement.
Gotcha.
I think you would want to start out by assuming the uninsurability threshold is sort of on the lower end. And then if they can prove, well, I can insure for more than that, then you would say, okay, harms, the expectation of harm or the possibility, the risk of harm is below that. We'll handle that with compensatory damages. Since you've shown you can take out $100 billion insurance policy, then that's going to be the cutoff. Risks of harms above $100 billion, those will be what go into the punitive damages calculation.
Right. And wait, did you say 10 million or 10 billion
10
for
billion.
how much people? 10 billion. Okay. And I guess to sort of ballpark that, like in the US, the value of a statistical life that regulatory agencies use is like $10 million per life or something.
Mm-hmm.
So 10 billion is like you can get insured for like the legal liability for killing 1,000 people, but like not 10,000.
So that's the right order of magnitude. As I explained in the paper, the numbers that are used by regulatory agencies are a little bit different than what's used in tort judgments. Those tend to be a little bit lower, in large part because the way mortality harms are valued don't actually value the value of the person's life to them. Sort of weird quirk of tort law that I think should be fixed for other reasons and is more important in this context. But that's sort of a tangent.
Sure. Gotcha. So this is the scheme. In the paper, you sort of focus on how it could be implemented in a U.S. context. If people are listening from like other countries or other legal systems, like how widely applicable is this sort of change?
So I guess there's two ways of answering that. I think the beginning of the paper that lays out like what the ideal regime looks like, I think that's true regardless of sort of what status quo legal system you're working from.
Okay.
In terms of what doctrinal or what legal levers you'd have to pull to get to that outcome or to get to that regime, that's going to vary across countries. I would say in any common law country, so that's basically English-speaking countries, tort law is going to be broadly similar. There will be some detailed difference, particularly products liability regimes, since those came later, are going to be different. But the basic structure of negligence law is going to be pretty similar across all common law countries. And so a lot of the same considerations are going to come into play. But I would invite scholars working in other legal systems to sort of flesh out what this would look like and precisely sort of what levers you have to pull in their system.
Gotcha. So one somewhat basic question I have about your scheme is suppose that party or company A makes this like really big super smart foundation model. Party B fine tunes it, makes it really good at a certain task. Party C then like takes that fine tuned model and sells it or deploys it or something. Suppose the model that C deploys causes harm. Like, who are we imagining suing for that?
So who's suing is easy. It's whoever is harmed, right? I think you're asking who's sued.
Yeah.
Okay. So I think you could potentially sue all of them, right? And so if you're talking about under my regime, where my preferred regime, where we're treating training and deploying these models as abnormally dangerous, you would have to sort of figure out at what step and which actors undertook these abnormally dangerous activities, right? If all of them did, then strict liability would apply to all of them. If the way the application of the standard works, you would say, well, this step in the chain wasn't abnormally dangerous, then that would be assessed under negligence principles. And you'd have to be saying, well, did they breach some duty of care, right? But in principle, there could be what's called joint and several liability, where the plaintiff can sue all of them or pick which one they want to sue. You can never collect more than the full damages, but you can sort of pick your defendant. Now, different states have different liability regimes for that purpose. So most states follow what's called joint and several liability, which means you can collect the whole judgment from any one of them, and then they can sue their joint tortfeasors, they're called, for what's called contribution, basically for their fault apportioned share. Then there's other states that use what's called several liability with apportionment, where you can only sue each defendant for their fault apportioned share of the liability. And fault apportionment is just this idea that if you have multiple defendants or multiple tortfeasors that are causally responsible for the same injury, you do some sort of allocation based on how faulty their conduct was, or in the concept of strict liability, like how liable they are. That concept doesn't apply as well in the strict liability context, but you would want to do a similar analysis.
Okay, but broadly, the sense is like, well, a court would just, or the court would just decide like, who was actually responsible for the really dangerous stuff that the AI ended up doing, and they would be liable for the thing.
So I want to make a distinction there. When you say courts, I assume you mostly mean judges. So there's different roles that judges and juries have in this process. Judges
Hmm.
resolve questions of law. Juries resolve questions of fact is the high level distinction. And so, say in a negligence system, breach of duty is a question of fact, but what the duty is a question of law. If we were
Okay,
talking about the threshold question of is this activity abnormally dangerous such that strict liability should apply, that's a question of law that a judge would resolve.
okay, I think that makes sense. And so I guess the final kind of framing question I want to ask about this is, um, it seems like a lot of this would be implemented on the jury side, right? Like a judge would tell a jury, this is roughly how you should figure out the damages, and go and deliberate and tell me what you decided. Is that right?
So certainly the actual damages calculations would be fact questions that would be decided by a jury in a typical case.
Hmm.
Um, the way judges review those is if they conclude that no reasonable jury could have reached a given result, then they can overturn it. But juries are supposed to have pretty wide discretion. Um, Now, whether punitive damages would be available at all is a legal question. It's a legal question
Okay.
resolved by judges. So under current law, it requires malice or recklessness as a sort of threshold requirement for punitive damage to be applied. There's also various limits under the Due Process Clause of the Constitution that limit sort of the ratio of compensatory damages to punitive damages. Those questions would be resolved by judges. And so juries would sort of be operating in the confines of those legal rules.
Gotcha. I guess my question is, one could imagine that juries are like really good at assessing these kinds of things. They're just very good calculators. They really figure it out. One could also imagine that juries just sort of roughly do what they feel is right, and maybe they're like forced to be in a certain range by a judge, but like maybe they're kind of random, or maybe they like stick it to the bigger party or something like that. And in the second world, it seems like it's just going to be hard to implement this kind of scheme because maybe we just can't tell juries what to do. So I guess my question is, how good are juries at like implementing formulas and stuff that judges tell them to?
So most damages calculations are pretty black box, right? It's like, well, what's the pain and suffering? For certain things we can assess better. So like lost wages are easier to quantify, right? Pain and
Hmm.
suffering is inherently pretty hard to quantify, and that's regularly part of damages awards. We just sort of deal with the fact that there's going to be experts to testify, and then juries sort of come up with a number, right? In this context, I think you would have dueling experts, right, where different experts are testifying and saying, well, this was the risk. Obviously there is deep disagreement in people who think about AI alignment, AI safety, about how likely these catastrophic outcomes are. Now, hopefully the context in which a system failed in a certain way, where it looks like it could have gone a lot worse, will be probative on the question. We're not trying to ask the question of what's the global probability that human extinction will be caused by an AI system, right? We're
Hmm.
trying to ask, what is the probability that this system, what's the probability that the people who trained and deployed it when they made those decisions, what should they have thought the risk was, right? And we can update on the fact that it failed in this particular way. We don't want to over update on that because in some sense, like ex post, the risk of a worse harm is zero, right?
Hmm.
And they didn't know it would fail in this particular way. But the fact that it failed in the way it did can reveal some things about what they knew or should have known at the time they deployed it, right? And so I think, yeah, juries aren't going to do this perfectly, but I also don't think they need to, right? So what really matters here is the expectation that if you take a risk, you're going to have to pay for the expected harm arising from that risk. And so as long
Hmm.
as juries aren't systematically biased in one direction or the other, as long as they're very roughly, noisily coming up with a number that tracks the risk, that's going to do what you need to do in terms of generating the expectations of liability. So that's a failure mode I'm sort of less worried about than others.
Okay. And so just to like give color to this, it sounds like maybe what would happen is like there's some sort of trial based on some like harm of you know resulting from something kind of like AI misalignment, and then like the defendant's legal team brings up some expert to say like, oh, this wasn't that bad and it's not that related to really scary harms, and the other expert says no, it's like really bad, and somehow like the juries are picking between like different people suggesting different things about what the damages can be that are kind of guiding their assessments. Is that a reasonable thing to imagine?
Yeah, that's how I would expect a trial like this to go, or the damages phase of a trial like this to go.
Okay, great. I guess a question I want to ask is, if I think of most AI governance work, I think that it kind of operates in a framework of saying, okay, our plan has two parts. Firstly, there's just going to be some process where like the government or a bunch of smart scientists figure out what AI can do, how scary it might be, and make that really legible to regulators. And then secondly, there's going to be some kind of law or some kind of regulatory body that says that if you make a really big scary AI, we're going to set out some rules for you to follow, and you just have to follow them. And we're going to design the rules so that if you follow those rules, the AI should hopefully be safe. Um, and this feels like your proposal feels like kind of a different flavor than these sorts of proposals. So I guess I wonder like how you think these kinds of schemes compare.
Okay, so to my mind, the key advantage of a liability framework is it doesn't require that you and the government know what specific steps have to be taken to make your system safe. I don't think we know that
Hmm.
right now. Maybe we'll get there at some point, right? But I don't want to rely entirely on the government being able to specify a procedure that makes your AI system safe, right?
Hmm.
And so what this does is what liability does is it shifts the onus to figuring that out onto the companies where, the labs where most of this expertise resides, right? I think it's going to be difficult for government to sort of bring the kind of expertise in-house that gets them to where the leading labs are. And so and even the leading labs don't really know how to build safe systems right now, right? So I want
Hmm.
them to not only be like throwing everything they have in terms of like once they've made a decision to deploy, making it safe, but I want them to, if they're not confident a system is safe, if they think deploying a particular system, given the current state of knowledge, creates a 1 in a million chance of human extinction, I want them to wait 6 months until like better interpretability tools come around, or whatever the idea is. I'm not a technical AI safety researcher, right? But I want them to be thinking like, I need to be as cautious as I would be as if like I own the world, basically, right? And if destroying the world was
Hmm.
going to destroy all that value for me, right? And that's not to say that there's no role for what I would call prescriptive regulation of the kind you were describing. But I think what's really important in that context is that those prescriptive rules don't preempt or displace the tort liability, right? So sometimes judges interpret regulatory schemes as having a preemptive effect, either because they're viewed as conflicting with tort law, or they're viewed as occupying the regulatory scheme is viewed as having occupied the field, and so impliedly preempting the tort regime. I think that would be a really bad outcome. So you can avoid that pretty easily in any sort of legislation that's enabling a new regulatory program by including what's called a savings clause that expressly disavows any preemptive effect. And once that's in place, I think we can talk about, are there specific measures that would buy some safety if we require them? I don't think those are necessarily bad ideas. I think some are more valuable than others, but I don't think we want to rely entirely on
Yeah. I guess it's sort of to me it seems like the distinction is these sorts of rulemaking schemes, they're sort of like the rules, the stuff you have to follow, it kind of comes like very early in time.
that.
Maybe like before you know as much what's happening. Whereas if you can do it right, something like a tort law scheme, like it brings in the legal force, at a time where there's some like medium range problem with your AI that's
Mm-hmm.
like not so bad that your legal system doesn't function, but like, bad enough that you kind of know more what happened. And like in my mind, it seems like the advantage is that it's sort of a more informed place to make these decisions, um, such that like AI companies optimizing for that are you know basically going to be doing better things than if they were just optimizing for like following like set rules. Does that sound
Right.
right?
So a rule that you set through regulatory policy may not pass a cost benefit test, right?
Hmm.
The government's gonna so you might have some unnecessary rules, and there also might just be things you didn't think of to require, or you decided not to require that would have bought you a lot of safety, right? So if you get the rules perfect, right, if you require everything that passes the cost benefit test and you don't require anything that doesn't, then maybe a regulatory regime is sufficient and better, right? But I don't have confidence in this domain that regulators are likely to approach that.
Yeah, I guess there's a difficulty where like on some level you're sort of hoping that you have that developers are able to figure out like what the right cost benefit is for themselves to do, but also there are kind of obvious problems with them like setting regulatory policy and uh, I, yeah, I guess I think of it as like just an interesting way to solve a knowledge problem. um
Yeah, it's also worth pointing out that some forms of prescriptive regulation work really well with liability. So in particular, there's proposals for these AI model licensing regimes, right? And I think that
hmm,
would pair really well with a liability insurance requirement system, right? So instead of the decision being binary, yes or no, do you get a license or not? What the regulator would do is decide, here's how much liability coverage you need in order to deploy this system. Here's the worst amount of harm we think you could do, right? And then you could deploy it if you can convince an insurance company to write you a policy you can afford. And that's going to depend on, maybe there would be some set of alignment evaluations or safety evaluations that they rely on in order to do that underwriting process. Yeah, so I think you want the decision about whether a system is deployed to depend on sort of whether its expected benefits for society are more than its expected costs. And if they have
hmm.
to buy insurance against the worst case outcomes and convince an insurance company they can afford it, that's a pretty good proxy for that. Whereas I think I'm less trusting of a sort of a binary government decision, like are we going to license this model or not?
Yeah, I guess. Yeah, I actually want to talk about synergies because I think there's also a synergy like in the fork of the plan where like we're gonna have NIST figure out like what kinds of AI designs are more or less safe, or figure out like ways of evaluating AIs for danger. It seems like this potentially has a synergy with the tort law plan.
I think yes, certainly NIST. I guess there's two different ways that could work. So one is if we're still in sort of negligence world. If my ideas
Hmm.
don't take the world by storm and we don't have strict liability on abnormally dangerous activities theory, then NIST promulgating these standards, if you're not following those standards, that's at least going to be evidence of negligence. Now, there's a doctrine called negligence per se, that if you had actual regulatory requirements and you don't meet those, then that would automatically be negligence. But if they're just sort of guidelines that NIST is issuing, that would be indication that you're not exercising reasonable care, but it wouldn't be dispositive.
Hmm. Yeah, I think there's. I was imagining also like if we do adopt your proposal, it seems like this kind of thing might be informative of like how risky that activity actually was. Um,
So how much uninsurable risk you took when you deployed it if you didn't follow the standard? Is that the idea?
Yeah, or like maybe it's not a standard, but maybe it's just like some kind of measurements of like, oh, we've there's some rule that you have to submit models to this organization, and like this model got a like blaring red light,
Mhm.
and then it caused some sort of problem, and that's like even more evidence that like there was something like pretty dangerous about it.
Yeah, so I definitely think there's scope for more technical work in terms of evaluations of these models, both in deciding whether to deploy them and deciding how much insurance you have to take out, and for doing these damages calculations. If harm has happened, can we try to use sort of post hoc evaluations to try to figure out, well, could it have gone a lot worse, right? What would that have looked like?
Sure. I guess the next thing I want to compare to is the so in your paper you cite this blog post by Robin Hanson about fume liability, which to my knowledge I think is the only previous time people have talked about a scheme roughly like this. And he imagines proposals sort of similar to yours, except there's kind of a fixed formula where they say like, okay, you're going to assess punitive damages, and the punitive damages are going to be based on like how many items on
Mm-hmm.
this checklist of like ways AI could kill everyone. How many items did you check off? And the more items on that list, the worse the punitive damages are by kind of set formula. Um, So your proposal, I take the main difference to be that instead of being the strict formula, you like people just have to figure out like how much would trying to prevent this certain harm that actually occurred, how much would that prevent like really bad catastrophes that could have happened. So I'm wondering, what do you think about kind of pros and cons of each one?
Sure. So I think I talked to Robin about this. His motivation for having that formula was to limit the discretion of judges and juries. Um,
Hmm.
I see that as not particularly viable in this context, since his formula at least strikes me as fairly arbitrary. It's taking it to the power of the number of these different criteria that are checked off. I think a lot of those
Hmm.
criteria are not actually binary, right? So it's unclear how you would implement it in cases where it's like sort of kind of self-improving or something. Um, so I think that's an issue. I think weighting all these factors equally doesn't seem super persuasive to me.
Hmm.
But I do see the value in sort of having a formula. That said, I do actually I provide a formula for my formulation of punitive damages. There are a lot of those sort of variables in that formula are going to be difficult to estimate, so that's a real challenge. But I think the advantage of it is it's tracking the thing we ultimately care about, right? It's like how much harm did you risk, and how sort of elastic is that with the harm that we actually realized here, right? Um,
Yeah.
and so um, I think I would like to see a lot more work to sort of put me on the bones of how to estimate the parameters in that formula. But in my mind, you should be like aiming at the target and doing as well as you can, as opposed to sort of, I think it's like at first blush it looks like straightforward to apply Hanson's formula, and that when you really like unpack it, I think there's still going to be a lot of discretion there, and so I don't think it. Um, I think maybe it limits discretion a little bit, but not as much as you'd like, and it's not like reliably. It's like loosely correlated with the thing we care about, but it's not going to reliably track it in the way that my preferred approach would. Does that make sense?
That makes sense. I guess I could imagine. Suppose we don't use Hanson's formula in particular, but suppose like what we do is like the world just spends a year. We look at your formula and then we say like, okay, what's something kind of like the Hanson's formula that really would approximate what your formula tells us to do, but we're gonna try and like have something that you can really nail down. We're gonna, to the greatest extent possible, we're going to have something where there's very little discretion on judges and juries, so they can apply it like sort of automatically. And we're gonna lose something along the way. It's gonna be like a bit of a bad approximation, but hopefully it's going to be like really predictable. And we're gonna lose some value of aiming for the ideally optimal thing, but we're gonna gain some value of predictability. And I'm wondering, like, how do you see that trade off? Like, how should we think about it?
So I think that would be really valuable. There's a question as sort of how that will be implemented, right? So one thing you
Hmm.
could say is like, look, someone comes up with that formula, you have your expert testify about it. Juries can incorporate that, right? It's the same way that we incorporate any sort of scientific expertise in that domain, right? I think that is the most likely pathway if this is going to happen in sort of a common law, judge created way, right? I think it's unlikely that judges are going to like create a rule of law that say juries have to follow the specific formula that somebody came
Hmm.
up with. On the other hand, if this is done via legislation, right? Um, Certainly, legislators, if they want to, can sort of hard code that formula into the statute, right? And then juries have to follow it, right? So if you have a formula that you think is like really good and unlikely to be improved upon, or if you think that okay, if we come up with something better, we can amend the legislation. If it's good enough, then I could see, sort of compelling judges and juries to follow it. It would sort of just depend on sort of how good you think the formula is and how easy it
Gotcha.
is to estimate the parameters in it. So if you have a really good formula that if you know the parameters, I think my formula is totally determined if you know the parameters, right? The problem is estimating those is really hard, right?
Yeah.
If you have one that has like easily estimable parameters, right, and you're just saying, jury, you have this narrow task of like coming up with good estimates of these parameters, and then that's all we're gonna ask you, and then like mechanically that will produce a damages award. I think that would be great if you can do it. I don't think technically we're there right now.
Yeah. I guess it also, like, one difficulty of this is, but like this seems sort of similar to formulas that get used in criminal law, right? Like sometimes like legislatures want to say, okay, we're going to have some sort of mandatory minimums, or we're going to like we're going to just have some rule, and we're going to ask judges and juries to like, or I guess in criminal law it's judges, but we're going to ask judges to like basically mechanically apply the rule. And I get the sense that the legal profession kind of dislikes this, or judges just kind of dislike this. And so firstly, I'm wondering if you think I'm right, and secondly, like, to what extent does that suggest that we should like be shy of implementing a like rigid formula here?
So I think mandatory minimums in particular are fairly crude, right?
Hmm.
And there's this general trade-off in law, what you may call rule standards, discretion versus rules, right? There's this idea that the more sort of discretion you give judges in individual cases, the more you're going to be able to sort of accommodate details of cases that might not be captured by like an overbroad rule. On the other hand, you're going to have like a lot more noise and potential for bias if you let judges and juries have more discretion, right? And so there's this basic trade-off.
Hmm.
I think what's new in this context is there's like a competence issue, right? That it sounds like you don't totally trust juries to be able to evaluate these questions, and so you want to like make their job a little easier, right?
Hmm.
And so, I think we do sort of like have a way of dealing with that you can different people have different ways of judging sort of how well it works, right? Of, letting juries hear, lay juries, non-expert juries hear from experts and then adjudicate the credibility of those experts and then come to a determination. But I think if we had a formula that was good enough, I think it would probably want something better than just like you commit X felony, you get a minimum of 10 years, right? I don't think
Hmm.
something of that level of simplicity is gonna work for estimating the uninsurable risk arising from an AI system. I don't know what that would look like. But I think if you had something sufficiently sophisticated where the parameters were easier for the jury to estimate, again, I don't have a strong sense of what that would look like, but I think that could be really useful.
Okay, fair enough. So another kind of proposal I want to compare against is a thing you mentioned like very briefly early on, something like Pigouvian taxation, where we say that like, doing this kind of activity is broadly dangerous, and we're just going to say like, whenever you make a model that's X big, or maybe a model that like trips up, X number of dangerous capabilities or something, that's just like inherently risky, and therefore you have to like pay a certain fine or a certain tax, kind of regardless of what happens. So similar to like a carbon taxation scheme. Um, and these kinds of schemes are often like considered pretty desirable in the settings where like there are pretty broad based harms that could occur. Um, so I'm wondering what you think about schemes like that in
So
this
I'm
setting.
a big fan of Pigouvian taxes generally. In my earlier life, I was a carbon tax advocate. A lot of my work is on climate change law and policy.
Hmm.
I think that there's two big differences between, so I say, the climate context and the AI risk context. So
Hmm.
one is if you are harmed by some climate outcome, right? It would be really hard to come up with like how you can bring a lawsuit, right? Um,
Yeah.
because everyone in the world contributed to that, right? To say that there's like a but-for cause of any particular ton of carbon being emitted that caused your injury, that's going to be a total mess, and you basically need to sue the whole world, right? That's one problem.
Right.
So that's like the thing that makes climate change harder to use this liability tool for. Conversely, it's really easy in the climate context to say, okay, we know what the unit of generating risk or harm is. It's like a ton of CO2 equivalent, right? And so we can say, okay, we might disagree exactly about, how much risk or how much harm you generate by emitting a ton. There's different estimates of like the social cost of carbon, right? But it's like we can measure like how much you did of that, right? We can come up with some tax and apply it, right? I think both of those are flipped when we talk about the AI context, right? So AI
Yeah.
systems are likely to harm specific people, right? And more importantly, it'll be specific systems that harm them, right? So it's not like, oh, it's like the existence of AI is what harmed me. No, it's like some specific system was deployed and that harmed me. That's who I know how to go sue, right?
Hmm.
And it's not as if, so all tons of CO2 emitted to the atmosphere do the same amount of damage, right? Now, maybe like a marginal ton at some point is worse than others, but like two different people emitting them at the same time, right? Me driving my car and you driving yours, right, are doing just the same damage, right? Um, and that's not true reliably for building an AI system of a certain size, right? You want to differentiate between companies that are or labs that are taking more precautions, are doing more, doing more alignment research, taking more steps to make their system safer. We don't want to just say we don't want to just like tax AI in general, right? We want to tax misalignment, right? So one framing that I really like is people worry about, alignment tax, that it's costlier both financially and in terms of time, other resources to build aligned systems, right? And so one thing you can think about AI liability doing is creating a misalignment tax, right? And hopefully that's bigger than the alignment tax, right? And so, but if we could perfectly assess at a time a model is deployed how risky it is, then maybe that would work well. But then if you could do that, then you could just have, some binary decision about whether you're allowed to deploy, right?
Yeah.
Maybe you might still want to tax because there's uncertainty about what the benefits of the system are, right? So you want to, but I think we're not in that epistemic position, right? We don't have the ability to assess ex ante how risky a system is. Once it's done harm in particular ways, I think we'll have more visibility into that. And so that's why I think a liability regime works better in this context.
Yeah, that makes sense. I guess a final thing I want to ask is a thing that it seems like this proposal is kind of really targeting is externalities from from AI research. So it's sort of imagining a world where people who run AI companies, they like basically know what's up. They basically know like how risky systems are and what they would have to do to make them less risky. And the reason they don't is that they're like inadequately incentivized to, because the world ending is like only so bad for them, or really bad catastrophes. They're only so bad for the AI company, but they're much worse for the world. And I think like it's not obvious to me like if this is the right picture to have, right? Like we see like pretty different assessments of like how what are the chances that AI could cause really serious harm. Um, like the world ending, like the really serious harms that like X risk people talk about. You know, they're not fully internalized, but they're like quite bad for the companies involved.
Well, orders of magnitude less bad for them than for the world.
It's true, but like I guess
So if you have a
yeah,
1 in a million chance of destroying the world, but like a 50% chance of making $100 billion, right? The calculation for you looks a lot different than the calculation for the world, right? That's a negative expected value bet for the world, but a positive expected value bet for you.
I think that's right. I think like on views where the probability of doom is like way higher than 1 in a million. Like I think a lot of people think that the probability of doom is like higher than 10%.
From a
And
specific system,
yeah, maybe not from a specific system. Maybe from AI development in general. So yeah, I guess my question is like how do you think we should figure out like if I'm assessing this, how do I tell if like most of the risk is like externalities versus like individual irrationality or stuff like that?
okay. So I think that's a fair critique that say, okay, maybe the people who buy these X risk arguments, the people at say Anthropic or, some of the people at OpenAI at least, right, that
Hmm.
DeepMind, right, are going to have even more incentive to be cautious. But like, Meta, Yang Ku doesn't believe in an X risk really, right? And so he's not going to be so worried about this. And I think that's
Yeah.
true if you only have the liability part of my framework. If you have
Hmm.
the liability insurance requirements part of it, then you have to convince an insurance company that's going to be a much more cautious actor, that you're not generating these risks. Because that's going to introduce that more cautious decision maker into the loop and put a brake on the process. And so I think I'm less worried about insurance companies that sort of their whole job is to be cautious, right, and to avoid writing insurance policies that are gonna pay out more than they cost in expectation, right. I think that's going to be an important framework for the actors, that the main problem is sort of their assessment of the risk rather than their incentives to account for it.
Yeah. I think this works for the problem of AI developers who have like abnormally low estimates of the risk. So I guess I'm looking at a world where I feel like there's a lot of disagreement about AI risk, and it seems like this kind of disagreement, like on the one hand, it seems like it's kind of the motivation behind like some sort of tort law scheme rather than like, well, we just know what to do, so we're going to make a law that says you have to do that. But it seems like it causes some problems, partly in that like AI developers or maybe even you know insurance companies that AI developers have to buy legal liability insurance from, they might know like they might not know what kinds of things to avoid. Um, it also seems like it means that like these sorts of pervasive disagreements are going to make it really hard for juries to assess like how big should the punitive damages be. So one might worry that like we just have so much disagreement that this kind of liability scheme can't really help us. Um, what do you think?
So I think I want to distinguish two different objections there. So there's an objection that this disagreement makes it hard to implement the formula, or it makes it
Yeah.
hard to implement the framework, or that this disagreement makes it so that if you could implement this framework, it wouldn't buy us that much safety. And so I think the concern that it's hard to implement, I think, is true, right? I think a
Mm.
lot of technical work needs to be hashed out, needs to be done to implement this framework reliably. I think you can implement it in sort of rough and ready way now, and that would still buy you a lot of risk mitigation. But there's a lot of refinement that could be done, a lot of knowledge that could be built, consensus that could be built that would allow you to more reliably track what the risks that these companies are taking are. And that would make the framework more valuable. In terms of, and the other point I want to make on that is that whatever you think these sort of epistemic burdens of implementing this formula are, they are lower, this framework are, they are lower than for implementing prescriptive regulations, right? Because you
Yeah.
not only have to know how big the risks are, you need to know what to do about them, right? Um,
Yeah.
and so, yeah, I think if your concern is our like poor epistemic position with regard to AI risk, I think that tends to favor liability relative to other approaches, not disfavor it. Then there's the question of is it gonna influence behavior in the right way? Because people might have different beliefs. So I made the point already about liability insurance and how that introduces more cautious actors. I think if what you're ultimately saying is like, look, people building these labs are still going to make mistakes, right? They might deploy a system that, based on everything anyone could know, right, looked like it was going to be safe, and then it wasn't, and then we're all dead, and like, who cares if in theory there should be liability for that? And I think what I want to say is short of, an outright ban on building systems beyond a certain level or certain kinds of systems, I just think policy is not going to solve that particular scenario, right? What we want
Mm.
from policy is aligning the incentives of these companies with social welfare. Maybe we also want to subsidize alignment research in various ways, right? But there is a sort of irreducible technical challenge here, right? That I think you're asking too much of policy if you want it to solve all of that.
Yeah. I guess like it. If I kind of think about the question, like it's most persuasive. Like the case for regulation is most persuasive in a world where like these AI labs they don't know what they're doing, but I know what they should do, right? Um, and but in a world where like we're all in kind of similar epistemic positions, then maybe like uh this sort of tort law approach seems like it makes more sense.
Or if the labs know better, then so
Or if
I,
they know
I,
better,
I
yeah.
mean, maybe you like Daniel Filan know better than what the folks at OpenAI do. I don't think
I
Congress
don't know
knows
about
better,
that.
right? So like I think Congress is going to listen to a lot of experts, but I don't know if you watch what goes on in DC, right? The idea that they're gonna write legislation that regulators are going to come up with something that like reliably makes us safe. I'm just very skeptical. I think they can do some things that are helpful, but that it's not going to be anywhere near sufficient. I think some of the things they end up doing might be harmful, right? I think politics and regulatory policymaking is very messy, and so I think if you're relying on that to make us like absolutely safe, yeah, I wanna pour some salt on that. Also, even if your idea is okay, let's just like the thing that I was throwing out there is the extreme position, like let's outright ban development of systems beyond a certain level. I think that even if you could make the domestic politics in the U.S. work, which I don't think you probably can, and even if you thought that was desirable, I think enforcing that globally is going to be extraordinarily difficult, right? Now, some of that you could apply some of that critique to liability too. I think that's a much easier lift.
Gotcha, gotcha. I also want to ask, for this approach to work, it seems like we need in worlds where the risk of misaligned AI causing like tons and tons of uninsurable damage, in worlds where that risk is really high, we need there to be a bunch of like intermediate warning shots where there are problems that are kind of like, you know, really bad AI causing like untold amounts of harm, um, but they only caused like, you know, a few $1 million worth of harm, so we can like sue about it and like actually have these cases come up. Um, can you paint a picture of like what these kinds of cases would look like, and yeah, how likely do you think they are?
Sure. So before I do that, I just want to offer some clarifications there on the framing of your question. So I don't think we necessarily need a lot of them, right? We need there to be a high probability that you get one for for a particular system before we get the catastrophe, before we get the uninsurable catastrophe, right?
Yeah,
And we also, so, but you don't need like thousands of them, right? You also um, don't actually need them. What you need more, if you have the liability rule in place, so say you've done this via legislation as opposed to sort of common law accumulation of cases, then what you really need is the expectation that these cases are likely to happen. You don't actually need them to happen, because what you wanted,
yeah,
ideally, the companies are expected to be liable. Therefore, they're like trying so hard to avoid these punitive damage judgments, and so you never get them, right? Now you might worry about some good harding problem there, where they iron out all the practically compensable cases without actually solving the catastrophic risk. That I think that is a failure mode I'm worried about. Um,
mm,
but but I think this could work without ever actually forking over any money, right? If it's just like if you just have that expectation, right? Okay. But
yeah.
now to
It
get
seems although it seems good if they're like, firstly, I guess like right now we're in this position where we're wondering how many of them to expect. It also seems good if there are going to be 10 such cases because, there's some uncertainty about whether people like get around to suing, and like maybe like you'd want to like average out some variance in like what juries are going to do to like make it a little bit more
right.
predictable. Like it seems like maybe you don't need 1,000, but
Yeah.
it seems like 10 would be much
So
better
at
than
the
one to
risk
me.
of seeming callous about the like real people that would be harmed in these scenarios, yes, I think from the perspective of catastrophic risk mitigation, more of these is better, and that you would
Mm,
want a few. I'm just saying in principle, right? You don't need very many, and in like if you really take like my expectations argument seriously, you actually don't need any. You just need the expectation of some, or the expectation of a
right.
high probability of some. Okay. Now to your question about what these look like. So the example I use in the paper is you task an AI system with running a clinical trial for a risky new drug. It has trouble recruiting participants honestly, and so instead of reporting that to sort of the human overseers of the study, it resorts to some combination of deception and coercion to get people to participate. They suffer some nasty health effects that are the reasons it was hard to recruit people in the first place, and they sue, right? So it seems like here we have a misaligned system. It was not doing what its deployers or programmers wanted it to do, right? It wanted to sort of honestly recruit people, but it sort of learned the goal of successfully run the study, right? It didn't learn the sort of like the ontological constraints on that, right? But it sort of so it seems like we have a misaligned system, but it, for whatever reason, was willing to display its misalignment in this non-catastrophic way. So maybe a few hundred people suffered health effects, right? But this isn't the system trying to take over the world, and now the system is probably going to be shut down, retrained, whatever. Now that we know it has this failure mode, but
Yeah.
probably the people who deployed it ex ante couldn't have been confident that it would fail in this non-catastrophic way, right? Presumably they thought it was aligned or they wouldn't have deployed it, right? But they probably couldn't have been that confident. They couldn't have been, more than, confident to more than like 1 in 1 million, that it wouldn't fail in a more catastrophic way, right? And so that's the kind of case I'm thinking about.
Okay. So it seems like, yeah, the general pattern is like AI does something like sketchy, like it like lies to people or it steals some stuff, and it does it like pretty well, but eventually like we catch it. And because we catch it, then like someone can sue, um, because we've like noticed these harms. I wonder, it seems like this applies to the kinds of AIs that are like nasty enough that they do like really bad stuff, but also like not quite good enough to just like totally get away with it without a trace.
So not good enough to get away with it, or not, or like they're myopic in various ways, right? So maybe it's
Mm,
the only, this system doesn't want to take over the world, right? All it wants to do is like really wants the results of this clinical trial, right? And because that's
right.
all it cares about, right? It's willing to risk getting caught, right? And actually, maybe it doesn't mind at all, because like by the time it's caught, right, it's achieved its goal, right?
Mm,
And if the people who deployed it could show they were like really confident that it was myopic in this way or had narrow goals in this way, then maybe they didn't risk anything that bad. But I'm sort of skeptical in that generic case that they can show that, right? And so, but yeah, another scenario you might think about is like a failed takeover attempt, right? So you have a system that's like, scamming people on the internet to build up resources, right? It's doing various other things. Maybe it even like takes over the server it's on, right? But at some point we're able to shut it down, right? And it harms some people along the way. I think that's another sort of like near miss case, right? So there's different ways you can imagine this going, where it either has really ambitious goals, but like isn't capable enough to achieve them, or maybe it is like potentially capable enough and we just got lucky, right? So I think there's different ways to think about this, because there's, when you think about like Joe Kyle Smith's work on like, these systems are facing trade-offs. They're gonna, they worry that their goals are going to be sort of gradient descented away, right? And so there's trade-off between like, do you help with alignment research now? Do you risk your goals being changed, or do you act now, even though there's some possibility that you might fail, right? And so
mm,
there, like, it could be that like even this particular system, if you had perfect knowledge about the system, like there would have been some non-trivial risk that this specific system would have caused an existential catastrophe, right? We just got really lucky, right? Or we got moderately lucky, however much luck you needed in that situation, right? I mean, theoretically, it could be like, oh, it was a 50% chance, right? Then you're already in uninsurable risk territory, right? And the actual damage award is going to be too big, right? But certainly there's going to be cases where it's like 1 in 100, 1 in 1,000, 1 in a million, right? Where a reasonable person would have thought that was the risk.
okay, sure. So I guess my underlying concern is that this kind of scheme might underdeter behaviors that like, or it might underdeter safety for like really, really capable AI systems. Um, Perhaps because I'm imagining a binary of either it's fine or it does really nasty stuff and gets away with it. But I guess the thing you're suggesting is like even for those systems, there's a good chance of like failed takeover attempts, or like maybe it's just myopic. And like you said, if we only need like a couple of those, even just in expectation, maybe that like makes it fine and aligns the incentives.
Yeah. So look, I want to be upfront about this. I think there is a worry that we don't get enough of the right, like the expectation, the right kind of warning shots, right? And so, or near misses. And if there are certain classes of harms for which there aren't near misses, or certain scenarios for which there aren't near misses, and therefore this doesn't give the labs enough incentive to protect against those, I think that's a real concern. I don't know what the shape of like of the sort of the harm curve looks like, right? Like how probable different kinds of harms are, and whether there's like sort of qualitatively different failure modes for a system, some of which aren't really correlated with near misses. It seems like there should be, right? If there's like lots of different variables you can tweak about the system, maybe that particular system isn't going to have near misses, but like a very near system would. And
Mm,
so still, the labs are going to have incentive to guide against that, to guard against that. But I think, yes, I think that is a real uncertainty about the world, that if you think we can be confident ex ante that certain types of warning shots or near misses are unlikely, that you're going to want other policy tools to deal with those kind of situations. I don't want to hide the
gotcha.
ball on that.
Fair enough. So I next want to talk about sort of just the this proposal as law. So the first question I want to ask is you're proposing, or the proposal in this paper is like a some amount of change to how liability law currently works. Um, but I don't know that much about liability law, so I don't have a good feel for like how big a change this is. Can you tell me?
Sure. So there's a few different as I said, as I've been saying, levers that I want to pull here. Some of these are pretty small asks, and then at least one of them is really big, right?
Yeah.
So we haven't talked as much about the sort of negligence versus strict liability calculation. So
Right.
right now, there's three kinds of liability that are typically going to be available. There's negligence liability, there's products liability, which is called strict liability, but in some details has some very negligence-like features. And then there's this abnormally dangerous activities strict liability, which is I would call more genuinely strict form of liability. Negligence liability is clearly available, but I think going to be hard to establish.
Wait. Before we go into this, what is negligence versus strict
Sure.
liability? What's the difference?
So when you're suing someone for negligence, you're suing them alleging that they breached a duty of reasonable care. So they failed to take some reasonable precaution that would have prevented your injury. And so the general principle of negligence law is we all have a general duty to exercise reasonable care or not to harm other people. And when we don't do that, when we fail to exercise that reasonable care, that can give rise to liability when that causes harm. So that's clearly available, but I think going to be hard to prove in this context because you would have to point to some specific precautionary measure that a lab could have taken that would have prevented your injury. When we don't know how to build safe systems, it seems like it's going to be really hard to say, oh, if you'd done this, the system would have been safe, right? Not impossible. It could be that there's some standard precautionary measure that, say, Anthropic and DeepMind are doing, but Meta isn't, and then their system harms someone. I'm not saying there's never going to be negligence liability, but I'm saying even if you had negligence liability for all harms where there's a breach of duty or where there's a provable breach of duty, that's unlikely to buy us as much risk mitigation as we'd like. In particular, that's because the scope of the negligence inquiry is pretty narrow. So say you're driving your car and you hit a pedestrian. We don't ask, should you have been driving at all? Say you're a licensed driver, but was the value of your trip really high enough that it was worth the risk to pedestrians that you might hit them? Or say you're driving an SUV, you could have been, you weren't hauling anything, it was just you by yourself. You could have been driving a compact sedan. We don't say, did you really need to be driving that heavy a vehicle? That increased the risk that you would kill a pedestrian. We just ask things like, were you speeding? Were you drunk? Were you texting while driving? Right? Those are the kind of things that are in the scope of the negligence inquiry. And so in the AI context, I think you can't say, oh, you just shouldn't have built this system, right? You shouldn't have deployed a system like this of this general nature. You should have been building STEM AI instead of large language models, right? Those aren't the kind of things that are typically going to be part of the negligence inquiry. Okay. So that's why I think negligence is not super promising. Then there's products liability, which is clearly available if certain criteria are met. So first of all, it has to be sold by a commercial seller. So if someone's just deploying an AI system for their own purposes that they made, products liability isn't going to apply. There's also this question as whether it's a product or a service. Ultimately, I don't think these distinctions matter a lot for the kind of risks I'm worried about. Because I think the test that's going to end up being applied is going to be very negligence-like. So when you're in the products liability game, there are three kinds of products liability. There's what's called manufacturing defects. This is like you ship a product off an assembly line that doesn't conform to the specifications, and that makes it unreasonably unsafe. And that is more genuinely strict liability in the sense that no matter how much sort of effort you put into your QC process, say your QC process is totally reasonable, and it would be unreasonably expensive to spend more to eliminate 1 in a million products coming off the line unsafe, still you're going to be liable if that 1 in a million harms someone, right? But I don't think you're really going to have manufacturing defects in the AI context. That would be you ship an instance of the model with the wrong weights or something. I just don't think that's a failure mode that we're really worried about. And so we're more likely to be dealing with what are called design defects. And there the test is whether there was some reasonable alternative design that would have prevented the injury. And you can see through the presence of the word reasonable there that you end up in a similar sort of cost-benefit balancing mode that you are with negligence. Again, if we don't know how to build safe systems, right, it's hard to show, like, yes, you don't have to show that they behaved unreasonably, that the humans behaved unreasonably. You have to show that the system was unreasonably unsafe. But I think that distinction doesn't end up mattering that much. And in practice, it's going to function a lot like negligence. There's also warning defects, which I think you could potentially have liability on. But even if you have all the warnings in the world, I don't think that's going to solve the problems we're worried about. Okay, so that leaves the third pathway, which is this abnormally dangerous activities idea. So there's certain activities that we say they're really risky even when you exercise reasonable care. And so we're going to hold you liable for harms that arise from the inherently dangerous nature of those activities. And there's a sort of meta doctrine as to what activities qualify as abnormally dangerous that I go through in the paper. I think plausibly under that meta doctrine, training and deploying certain kinds of AI systems should qualify as abnormally dangerous. But I think courts are unlikely to sort of recognize software development of any kind as abnormally dangerous, sort of on the status quo, business as usual. I think it's clearly within their powers to do this, to treat training and deploying AI systems that have unpredictable capabilities, uncontrollable goals, as abnormally dangerous activity. I think it does sort of meet the sort of technical parameters there, but I think it would require an understanding of AI risk that courts have not currently been persuaded of. But I think this is a move they should make. The courts could make on their own. It would not be a radical departure from existing law. I think it would be consistent with this broad doctrine, which is sort of be recognizing a new instance in which it applies. And so I think that's a relatively modest ask to make of courts, though again, I want to be clear, not the default that's likely. So that's one step. And so that solves the, like, can you get liability at all, right, for compensatory damages. Then there's the punitive damages piece, which is designed to get at these uninsurable risks. There, I think there's a much heavier lift. So there's long-standing punitive damages doctrine that requires what's called malice or recklessness, reckless disregard for risk of harm. And so, we talked before about how, even having provable negligence is going to be difficult in these cases. Malice or recklessness is like a step higher than that. You can think of it as basically like gross negligence, right? And so if it's hard to even...
Hang on. I don't know what gross negligence
really
is.
Bad negligence. It was really, really unreasonable what you did. Not just a reasonable person would have done it, but like even a normal unreasonable person wouldn't have done it, right? It's like a lot worse. It's like the cost benefit calculus is like lopsided, right?
Yeah. The image I have in my head is of someone saying, "Yeah, I know this could be risky, but I don't care. I'm doing it anyway." Which seems like a pretty high bar.
Yeah, it's a pretty high bar. And so, yeah, I think courts are unlikely to take the step of reforming punitive damages doctrine in the ways that I would like them to, because this would be such a significant change. Now, I do want to point out that if you think about the normative rationales for punitive damages, at least the one that I find most compelling is that, and that I think is the central normative rationale, is that compensatory damages would deter the underlying tortious conduct. That doesn't require malice or recklessness to be true. It requires something about the features of the situation that suggests compensatory damages are going to be adequate. It might be uninsurable risk. It might also be like most people who will suffer this kind of harm won't know that you caused it or won't sue because maybe the harm is small relative to the cost of proving it, right? And so maybe only 1 in 10,000 people who suffer will end up suing, and so maybe you should get punitive damages to account for the people that don't sue. But nothing about that requires malice or recklessness, and there is existing scholarship that argues for getting rid of this requirement, so it's not coming new in this AI context. But again, I think courts are unlikely to do this, and it would be a major doctrinal change. It would require both state courts to change their punitive damages doctrine, and it would also require the U.S. Supreme Court, in applying, again, the due process clause, to say that applying punitive damages in this context without these threshold requirements doesn't violate due process, that companies that deployed these systems were on adequate notice. I think that's not totally insuperable, but I think it's pretty unlikely as a matter of just the natural evolution of courts.
Yeah, I mean, and actually, I kind of want to ask about this because so your paper cites this this work by Polinsky and Chevelle, I guess their names, basically saying like, hey, punitive damages should just compensate for the probability of being caught. At least that's how I understood their abstract. That seems kind of intuitive to me, but also my understanding is that this was published like what 20, 25, 30 years ago or something, and apparently it still hasn't happened. So the fact that it hasn't happened makes me feel like a little bit nervous about making these sorts
You
of
should be.
changes.
I think that I think you should not expect the courts are going to follow my advice here, right? They didn't follow Polinsky and Chavel's advice. They're much more prestigious people than I am. They're like Harvard and Stanford, right? They're doing fancy economics models on this, right? I think you should not expect this change to happen from courts. I think they should. I think it's within their powers. Um,
Hmm.
I think we should try to persuade courts. I think litigants should bring these arguments and force them to confront them and ask courts to do it. I think all that should happen, but I would not count on that happening. What
Okay.
I do think is a more, but again, I want to be clear. I really think people should try, both because you never know, and one state doing it gets you a lot of value, and because I think it would put it on the table politically. Then you would say, look, we need legislation to overturn this, right? And so I do think, at least with regard to the common law issues, with regard to sort of what state tort law says, clearly state legislatures, if they want to, can change that requirement. So there's sort of a hierarchy of law in which statutes always trump common law. And so if a state wants to pass a statute saying either in this AI context or more generally that punitive damages don't require malice or recklessness, that's clearly something that state legislation can do. There's still the constitutional issues with that, although I think if you have a statute putting the labs on notice or the companies on notice, that that might accomplish a lot of the due process notice functions that the Supreme Court's worried about. And so it's not clear to me that that would be a constitutional barrier in the context of legislation.
Yeah. Can I ask about this punitive damages change? So this case for like having punitive damages compensate like the probability of like a case being brought. Um is that like is the thing holding that up that like legal scholarship broadly is not persuaded by it? Or is it an issue where like yeah, legal scholars are persuaded by it but judges aren't? Or is there some other issue going on?
So the short answer is I don't know, but if I were to speculate, I think, you know, Polinsky and Chavel's argument is really persuasive if you're thinking about this in a law and economics frame, and like that's all you think tort law is about, right? And
Yeah.
that's
So
basically
law and economics basically being thingy of law just in terms of like economic efficiency and like maximizing social utilities stuff. Is that
right.
roughly right? Yeah.
And so that's the frame that I tend to prefer.
Yeah.
But that is not dominant, right? And so there are other sort of ways of thinking about what tort law is for, particularly what punitive damages are for. So there's sort of an expressive function, expressing society's disapproval for the behavior that would more map on to this recklessness malice requirement, right? And so if you have someone that's doing something that maybe isn't even negligent at all, or it's a strict liability tort, or it's ordinary negligence, the idea that we want to like punish you over and above the harm you did doesn't sit right with some people.
Hmm.
Honestly, I don't think courts have really revisited this issue in a long time. Mostly what courts do is just follow precedent, right? Unless they have some good reason to reconsider it. I think AI arguably should give them a reason to reconsider it, that like we have this pressing social problem that you are well positioned to solve. Maybe the fact that this requirement doesn't really make sense from a law and economics perspective more broadly hasn't been that big of a deal in the past. A lot of the sorts of problems that you'd want punitive damages to deal with, we've dealt with through other policy tools for reasons we've talked about earlier. I think there's reason to be skeptical that those policy tools are going to be adequate in this context. We need to lean more heavily on tort law. So it makes it really
Hmm.
important that you get punitive damages right from this law and economics perspective, and they should reconsider it. Again, I don't think they're super likely to do that, but I think we should try. And yeah, I think I may be talking myself into thinking there's a little bit of chance that they would reconsider in this context. But yeah.
I also want to. Okay, I'm gonna try and like suggest some hopium, and you can like talk me out of it. So this. So I don't know. I glanced at this like Polinsky and Chevelle paper because it seemed like I don't know, not knowing anything about the law, that seemed like a kind of obvious change, right? And I read the paper and I noticed that like or well, I read like the first page, right? It's got a table of contents and it's got a little disclaimer at the bottom. And I noticed that in the table of contents, it's like, hey, it should be based on like, the probability of like this thing being like actually like it should be based on the probability of a lawsuit actually being brought, not based on other things. And in particular, it shouldn't be based just on the wealth of the defendant, because that's economically inefficient. And I see the thing at the bottom saying like, yeah, this was like sponsored by was it Exxon Mobil or something? Like my understanding is that basically like a big oil company paid them to write this paper basically in the hopes that this would be like more friendly to really big business.
Uh-huh.
And I have this impression that like people in the world kind of don't like the idea of changing the law to make it better for really big businesses.
Uh-huh.
But this change, it seems like, would make life kind of worse for really big businesses. And therefore maybe like everyone's going to be like a little bit more friendly to it because, people don't like the big guy. D- does that sound right? Am I being like too cynical?
Okay, so there's a few different ways I want to answer that. So, first of all, I think that's like good and bad, right? So,
Mm,
I'm talking to state legislators about, different, legislation to implement different elements of this proposal, right? And, a lot of them are afraid of doing anything that runs afoul of like the tech lobby, right? Or like they want to at
mm,
least neutralize them, right? They want to like, it's okay if they're not like really supportive, right? But in a lot of states, like having all the tech companies be against your legislation is like pretty bad, right? So
yeah.
that's one answer that like not obvious. That's a net good. But yeah, I mean, I do think there's sort of like a populist like in certain circles at least there is like backlash against big tech, and so like if your strategy is not like the inside game, if it's like making a big public case, then maybe that's helpful. Um, I'm gonna leave it to sort of like political entrepreneurs to sort of make those judgments. Then there's the sort of way this fits into the broader sort of AI policy ecosystem. And
Mm,
for that purpose, I think it's actually really valuable that this is like a relatively hostile to the incumbent big players proposal, right? Not as hostile as some of the like AI pause stuff, right? But like when you compare it to like licensing regimes that have sort of anti-competitive effects on some margins, I think there's a strong case that we should have antitrust exemptions for them, cooperating to share alignment research, to maybe to coordinate the slowdown on capabilities enhancements, right? I think there's reasons to think that like under current law that would violate anti-collusion principles, right? I think that there's good reasons for having exemptions to that. I think those ideas are generally like pretty friendly to the incumbent players. And there is an accusation that's sometimes thrown around that like, AI safety is this like psyop or whatever by the big tech companies to like
mm.
avoid competition and stuff like that. And so I think having some policy proposals in your package that are clearly like not in the interest of those big companies is useful, at least rhetorically. And so I think it does play that role, but I don't think, it's bad for big tech, therefore like automatically it's going to happen. That's definitely not my model.
Fair enough. So okay, all of this was sort of a tangent. I was originally asking, like, how big a lift is this in terms of changes to tort law that happen? You mentioned that, like, yeah, you have to make this change to like strict liability, which is maybe not so big. You mentioned that there's this change to punitive damages, which like is kind of big. And I sort of interrupted you there, but I think maybe you were going to say more.
Okay, yeah. So punitive damages is a pretty big lift. I think we've beaten that horse plenty.
Yeah,
Then there's other things. So liability insurance, like court just can't do that, right? Liability insurance requirements, so that would require legislation. I don't think it's like a big legislative lift, but it's just not something courts can do. So like,
yeah,
and then there's other things like that we haven't talked about. So there's this doctrine of what's called proximate cause or scope of liability. So say I cut you off in traffic and you have to slam on your brakes, but like we don't collide, you're fine, but it slows you down like 30 seconds. And then 2 miles down the road, you get sideswiped in an intersection, right? And you want to sue me and say like, look, but for your negligence in cutting me off, right? I wouldn't have suffered that later injury, so you owe me money, right? and I say,
Yeah.
no, it wasn't foreseeable, right, when I cut you off, that you would get in a collision 2 miles down the road. In fact, it's just as likely that I could have prevented a similar collision for you, right? And the courts are going to side with me there. They're going to say, I'm not going to be liable for that, even though I was negligent and my negligence did cause your injury. This is like an independent element of the tort of negligence. And so in the AI context, the question is like, what does it mean for the injury to have been foreseeable? In some sense, misalignment causing harms is clearly foreseeable, right? Like Sam Altman talks about it, right? Like if his system does it, like he's not going to be saying, like, couldn't see this coming, right? But the specific like mode of a misaligned system harming someone almost certainly won't be foreseeable, the specific details, right? And so it really depends on what level of generality that question is evaluated. There is this manner of harm rule that says, the specific manner of harm doesn't have to be foreseeable as long as the sort of general type of harm is. That helps a little bit, but there's still like a lot of wiggle room in how this doctrine is applied. There's not some sort of like high level change to precedent that I can ask for to say like, oh, you change this rule so that like there will be liability in these cases. It's really just courts need to be willing to apply a relatively high level of generality in their scope of liability or approximate cause assessments for AI harms. So I think, how big of a lift is that? I think not a huge lift, but like also not necessarily going to be consistent across cases. And you just want it to like generally be fairly friendly to liability. But it's a pretty mushy doctrine in that sense. Then there's something we talked about earlier where the way mortality damages are dealt with under current law. So there's two kinds of lawsuits you can bring when someone dies. There's what's called a survival action, which is basically all the torts that the decedent could have sued for the second before they died. So say, I crashed my car into you and you're in the hospital for 6 months and then you die, right? And in those 6 months, you racked up lots of hospital bills, you had lots of pain and suffering, you lost 6 months of wages, you could have sued me for all that. Your estate can still sue for all those things after you're dead. Right? That wasn't true of common law, but there are these survival statutes that allow basically the claims that you had at the moment you died to be brought by your estate. Then there's what's called wrongful death claims, which are also creatures of statute that say that designated survivors, so this is no longer your estate suing, this is specific people with a specific relationship to you, say your kids or your spouse or whatever, can sue for harms they suffered because you died. So maybe, your kids suing because they were going to benefit financially from you, that they were going to get caretaking services, whatever, right? In neither of those lawsuits is the fact that like it kind of sucks for you that you're dead, right? That's not something that can be sued for, right? In almost every state, right? And so if you think about like a quick and painless human extinction, where there's no survivors left to be suffering from the fact that their relatives are dead, if you take this like to its logical conclusion, the damages for that are zero, right? No lost wages, right? Because you died quickly, no pain and suffering, no hospital bills, no one's around. Not only not around to sue, but like there's no claim, right? Because they haven't suffered from your death, right? Because they're dead too, right? And so now I don't think courts are like likely to take that so literally if they're like figuring out, if they buy everything else in my paper and are like, okay, we're trying to do damages for how bad human extinction is. I don't think they're going to actually like take that to its logical conclusion and say the damages are zero. But I think there's a reason to be worried that in general, if we think most of the harm from AI misalignment or misuse is going to come in the form of mortality, that those harms are going to tend to be undervalued. So that would require a statutory tweak in individual states to say that wrongful death damages should include the value of the person's life to them. We have ways of estimating that. So as you mentioned earlier, regulatory agencies use a value of a statistical life on the order of $10 million. I think that would be fine, at least for U.S. lives in the tort context, but that would require a statutory change. I think not a huge lift, but would require a statute. I think because wrongful death claims are statutory to begin with, I think it's very unlikely the courts would try to change that on their own.
Sure. So I don't quite understand. So it seems like the case that we're really thinking about is like, an AI causes an intermediate amount of harm, and we want to assess these punitive damages for like how bad it would be if like, you know, some sort of like really bad catastrophe happened. Um, it strikes me that it strikes me as a priori possible that that kind of calculation could take into account the value of the lives, the value of the life years not lived. But like that could be different from actually suing for loss of life.
Well, if your theory of punitive damages is that you can't sue for these compensatory damages if they actually arise because they're practically non-compensable, then
Right.
presumably the punitive damages should be pulling forward those hypothetical compensatory damages, right? And like again, I don't I'm not so worried that like but if you just are like hyper logical about this and you apply existing compensatory damages doctrine, in that scenario, the number you get is zero, right? Now, again, I don't think like I think if courts are persuaded by all my other arguments, they'd be like really dumb to go there, right?
Sure.
And to say, well, if it causes lots of pain along the way, you can sue for that, but the actual human extinction is like, okay, that does seem crazy. I'm just pointing out like that is the logical entailment of the existing structure. Right now, you could say we're going to tweak. Instead of changing the statute, you could say, well, I'm going to have a slightly different conception of what these punitive damages are doing, right? Um,
Hmm.
and and they're not quite just pulling forward the compensatory damages. I think that courts could do on their own. I just want to point out, like, I don't think this is at all the biggest obstacle to making my framework work, but it just seems worth being like transparent about this quirk of mortality, the way mortality damages work. That, like, in theory, at least, could cause a problem here. And like, if we can pass legislation fixing that, it would make it a lot simpler and more straightforward.
Fair enough. So basically, we've got this like bundle of changes that where like that you might hope that courts or legislators make. This bundle is like, some amount of a big ask. Like, how often do those kinds of changes actually happen?
So, if what you mean by those kinds of changes, you mean reforms to make liability easier, the answer is
Hmm.
legislatively, they almost never happen, right? So, tort reform statutes are almost always, with the exception of some of the statutes I was talking about, like, wrongful death and survival action statutes, um,
Yeah.
are almost always to limit liability, right? So when people talk about tort reform, they tend to make it like, oh, liability insurance is too expensive. We need it's making healthcare too expensive or whatever. We need tort reform. What they typically mean is like making it harder to sue, right? Um, so if that's like your like your reference class that you're drawing your base rate from, it like doesn't look so attractive. Now maybe you think like AI is different enough that we shouldn't think of that as the right reference class. I think that's a plausible move to make. Um, but if that's what you're thinking about, then like you shouldn't be too optimistic. Um, Courts are, I think, are more inclined to make changes. They're more symmetric in whether they make changes that are like more pro plaintiff or pro defendant. There's certainly been changes like market share liability, like recognizing various forms of strict liability that have been plaintiff friendly. And so I think as I said, I'm like mildly optimistic about them making the strict liability and abnormally dangerous activities change. Again, I think that the punitive damages thing is like too big of a doctrinal move that I think courts are unlikely to make.
Mm.
And so I think we probably are going to need to rely on legislation there. The other thing we're saying in this context is like, if you think about this as like a tort reform problem, then maybe you should think it's unlikely. If you think that you're going to have a lot of energy at some point, a lot of political will to do something about AI law and policy, right? And those things include, some things that would be more draconian, like sort of just banning or creating moratoria on like training models above a certain level. Well, like saying you have to pay for the harm you cause is like a less extreme step than a ban, right? Or than a pause, right? And so once you think those things are on the table, I think you should think that you should be more optimistic about ideas like my liability framework. And so maybe you don't think like this is likely to happen tomorrow, but if you think there's going to be a future moment where there's political will, I want this like idea to be fleshed out and ready to go so that states or the federal government can pass it.
Fair enough. So another question I have about this is nominally this is about like catastrophic risks from AI, but the from AI part doesn't I mean, you talk about some AI specific things, but this seems like a fairly general type of proposal, right? Like, just whenever there's some risk of some sort of uninsurable harm happening, we could have like a pretty similar scheme. So, yeah, I'm wondering like what other effects do you think these kinds of changes could have, and have people talked about these kinds of changes before?
So I'm not aware of anyone proposing using tort law to deal with uninsurable risks before. I think typically the way we handle uninsurable risk is through some kind of prescriptive regulation. And those regulations
Hmm.
often preempt tort liability, right? So if you think of
Okay.
like a nuclear power plant, right? There is some liability for nuclear power plant, but the liability isn't really, the goal of it isn't really to change the incentives, right? There's various government subsidies to make the insurance affordable to but we mostly rely on, especially in the US, like regulating these things to death. It's like impossible to build a nuclear power plant in the US. It's easier in France, but even there, they're relying on prescriptive regulations, right? And so I think that's true broadly. So if you think about sort of like bio labs that are doing gain of function research, right? I think it's hard to bring a tort lawsuit for that.
Hmm.
We mostly rely on these like BSL certifications and stuff, biosafety level certifications, prescriptive regulations, right? So I think generally the thought has been it's hard for the tort system to handle this. We should lean on other policy tools. I think it is harder for the tort system to handle this, I think in the AI context, it's even harder for other policy tools to handle it, or at least to handle it sufficiently, right? I'm not saying this should be sort of our exclusive policy tool, right?
Yeah.
But I think there are real limits to what you can do with prescriptive regulation in this context, and so I want to lean more heavily on the tort system than you would when you otherwise would. I think if you made these doctrinal changes, it would, so the strict liability change would only really apply to AI. I think the punitive damages change in principle would tend to be more broad. It would be sort of weird to change it just for AI. But I think the implications of that might be pretty minor, since a lot of the areas where there are these catastrophic risks are the tort law is going to be preempted anyway.
Sure. I guess like one imagination I have is so during the Cold War, my understanding is that there were a bunch of near misses where like somebody like we almost set off a bunch of nuclear weapons, but we ended up like not quite doing it, right? Like maybe like the US Air Force accidentally drops a nuclear bomb like on the US and like it doesn't explode, but like 5 to 6 safeguards are off or something.
Mm-hmm.
And I'm imagining a world. So, in my understanding, there's a thing you can bring called a Section 1983 lawsuit, where if a government official violates my constitutional rights, I can sue them for the damages I faced. And one thing I could kind of imagine is like, suppose the US, suppose that the military like accidentally drops a nuclear bomb. It doesn't detonate, but it like 5 to 6 safeguards are off. They drop it on my field. It like damages my crops a little bit, or it's kind of nasty. I can imagine a world in which I bring like a 1983 lawsuit to the government, and not only do I like try and sue them for like the minor, damages to my actual property, but I also try and sue them for like, hey, you nearly set off a nuclear bomb. That would have been like super bad. Um, does that strike you as a way that this kind of change could be implemented?
So maybe, but there's a lot of complications in that context. So Section 1983, there's like lots of rules about when it applies, when this like waiver of sovereign immunity works. But yeah, I think that lawsuit's going to be tough. I also think I don't know, it doesn't necessarily make sense to me normatively in that context that you would, the government's not like a profit maximizing actor in any sense. And so like, is liability the right tool to, basically you'd be putting like the government paying means the public's paying, right?
Hmm.
Does that like change the incentives of the military in the right way? Not obvious to me that it does. So you can think of tort law generally as serving two functions, right? There's a compensation function and a deterrence function, right?
Right.
And so in the context of suing the government, I tend to think the compensation function is a lot more important. Whereas in the private context, I tend to think the deterrence function is more important, and the compensation is sort of like a happy byproduct of that. And so punitive damages are really about deterrence, right? They're not about compensation, right?
Sure.
There's even a proposal I have in the paper that maybe not all the punitive damage should even go to the plaintiff, right?
Hmm.
And so do I really think like the government's going to be that much more careful, the military is going to be that much more careful with nuclear weapons if there's this liability? Like maybe, but it's not obvious to
Okay, fair enough. Um, yeah, I guess like you mentioned, you could also imagine having a similar sort of scheme for like lab biosafety accidents. Like presumably some of those are run by like private
me.
companies. Maybe something there could happen.
Yeah, no, I think to the extent that's not preempted by the regulations, I think that would be a benign effect of this. That like, you know, and maybe it would be really tough to insure a lab that's doing gain of function research, right? And maybe that would be okay, right? You make it a lot more expensive, and then you'd have to say, well, like if the social value of this is large enough, fine, you can get a big enough grant or a big enough, expected profit from doing this research. Then okay, but like if you can't, then that suggests that this is a socially valuable activity at the level of safety that you're able to achieve, and so you just shouldn't be doing it.
Sure. So another question I have, more about the punitive damages change. Is there stuff like this in criminal law where there are additional like penalties for things that like that the government might not have caught you doing?
So if they didn't catch you, like it's hard to know like how we know that you did them. Um,
Oh, I mean like punishing a crime like more severely because we thought we might not have caught you.
so certainly your past record, even if it's not like a conviction, is taken into account in the sentencing context. Um,
Hmm.
but also I think an example that might map onto this that might be getting at the same sort of idea is like, attempted murder is different from assault, right? So
Right, right.
so you get a longer prison sentence if you like attack someone and you're trying to kill them, even if you don't, than you do if you just like beat someone up with there being like no indication that you were trying to kill them, right? And so I think
Hmm.
that's a similar idea going on in that context.
Interesting. Yeah, so actually just picking up on a thing you said earlier, yeah, in terms of difficulties of applying this kind of liability scheme to state actors, sometimes a thing people talk about is this possibility that AI labs will get nationalized or somehow there's going to be like pretty tight intermingling between like the government and like AI development. Would that pose difficulties for this sort of liability scheme?
So I think in a world where the government is taking over uh, AI companies, I think they're unlikely. There's something called sovereign immunity, so you can only sue the government when they waive that, when they allow you to sue them, right? I don't think it's super likely as sort of a predictive matter that the government's going to want to expose itself to a lot of liability and punitive damages in that scenario. So that's one question, is like whether this would be likely to happen in that world. And then there's another question of is liability like a useful tool in that world? I don't think the government responds to financial incentives in the same way that private parties do, right? And
Hmm.
so like if we're in that world where they're nationalizing it, both maybe because they're worried about risks, but also because like they're worried about like an AI arms race between like the U.S. and China or whatever, right? Is the risk of getting sued like really going to change their calculations that much? Not obvious to me that has the same incentive alignment effects that it does in the private context. And so, um, I think in some ways you have lower risk in that world, but I think in other ways that's a more dangerous world. It's not obvious to me on balance, like whether I'd rather live in that world. You're sort of moving all the key decisions like to the political process, and part of the advantage of liability is like, yes, you need the political process to like get the like high level decisions in place, but then you're like shifting the onus to these like private actors that have in theory at least more aligned incentives, right? As opposed to trusting like elections and regulatory processes and whatever military decision making to make the right decisions.
Fair enough. Okay, so I'd like to change topic a bit now. Mostly when I see people coming into doing work on AI alignment, um, usually they're either an AI researcher who's like come across alignment concerns in the course of AI being in the AI sphere, or like one of these like dyed-in-the-wool young EA professionals who like got into AI that way. It seems like my understanding is that you have like a decent background in environmental law. Um, how did you come across AI stuff?
So I've been sort of loosely affiliated with the rationalist EA communities for a long time. And so I've been aware of the AI risk problem for over a decade. Um, I never really, until pretty recently, considered working on it professionally. It wasn't obvious what role I would play. I
Mm,
wasn't thinking in terms of sort of what policy tools or legal tools would be relevant. Um, and so, it seemed like I'm glad some like technical researchers are working on this, but I thought of it as like a technical problem.
yeah.
I guess in the last couple of years, I started to reconsider that. And then last summer, I did this fellowship called PIBS, Principles of Intelligent Behavior in Biological and Social Systems, that brings together sort of like, non-computer. I mean, there were a couple of computer science ML types there, but it was mostly people in social sciences, economics, philosophy. I was the only lawyer that was part of this program, but it was about 15, 20 people that each are assigned a mentor. So I was working with Alan Chan from Mila, and he was really helpful on sort of like helping getting me up to speed on the technical side of some of these questions. Um, and so, yeah, I did this fellowship. We all spent the second half of the summer in Prague together, working out of a co-working space there, and got to learn from other people who were doing a project in this area. So that's the sort of causal story of how I got involved in this. Sort of intellectually, I think it's like not as big of a departure from my work on environmental law and policy as it might seem. Um, you know, we talked earlier about how like carbon tax is sort of like AI liability, and so I tend to approach my scholarship with a sort of law and economics frame, and sort of it's thinking through in a different context, but I'm thinking through a lot of issues that I'm comfortable with sort of the principles involved from other contexts. I also teach tort law, and so it was sort of natural to think about how to apply how that domain could be helpful to AI risk.
Yeah, like in some ways, I feel like there's a sort of strong through line of it seems like some of your work is on like liability, like changes to the liability system, and it seems sort of a kind with that kind of work.
Yeah, so I had a recent paper I think you read on the hand formula, which is this test for breach of duty and negligence cases and ways in which it might fail. So that was a more general, critique of the way tort law works. And now I think this paper sort of implicitly has a lot of broad critiques. I think you sort of suggested this, like a lot of the things that I think should be changed in this context really are problems with tort doctrine generally that the AI risk context is really just pointing up. And like really exposing. And so in principle, you could have written this paper without ever mentioning AI. I think it's worth being explicit about like why I care about it.
Yeah.
But yeah.
So suppose we like really do want to make these kinds of changes. How if the like AI X risk community wants to push for this kind of thing, in the legal profession, um, or among legislators, what do you think that looks like?
So I think there's a few different channels of influence. So the one that I have the most control over is just like convincing other legal scholars this is a good idea. And then like you create a consensus around that. Other people write articles saying it's a good idea. And then like there's a bunch of articles for litigants to cite to judges when they try to persuade them to adopt this, right? So that's one channel of influence that's like through the academic
Hmm.
pathway. Um, Another is just like lawyers out there bring these cases, right? And try to convince judges to adopt these different doctrinal changes. You can do it with strict liability even before you have a case where there's catastrophic risk implicated, and then as soon as there's any case where there's a plausible argument for uninsurable risk, then try to raise the punitive damages and get courts to consider that. And then on a parallel track, I think we should be talking about legislation, both for strict liability and for punitive damages, and potentially for other things like liability insurance requirements and changing the way mortality damages work. Those are all things that could be done by state legislation. And so I think that's people should be, who are interested in doing policy advocacy, that's definitely an avenue that I said I'm involved with, talking to some state legislators that I'd like to see more work on. In some states, this could be done via ballot initiatives. So certainly in California, It's pretty easy to get a initiative on the ballot. I think strict liability is like a pretty straightforward yes or no question that you could have a vote on. I think it would be a little tougher to do it for punitive damages, but I wouldn't put that off the table. Um,
Mm.
Liability insurance, I think, would be hard, but California seems to let lots of crazy stuff on the ballot initiative, so maybe.
Yeah, it's pretty. I don't know if you're familiar with the state constitution of California, but just like every 2 years, it gets added with some like random stuff that some ballot measure passed. Like I think the California state constitution includes text from a ballot measure that's basically about a scheme to like do some sort of tricksy accounting stuff to maximize the amount of Medicaid money we get from the federal government. So
Yeah, it seems
a
like
lot of stuff
not
happens in
a
California.
great way to like. I don't think California has adopted the optimal initiative process, but given that it exists, I think it should be used for this good purpose. And so
Sure.
I'd love to see someone, and I'd be happy to advise on any project that wanted to pursue an initiative like that in California.
Yeah. One thing I wonder, so you mentioned that like, this is kind of a law and economics framing on the problem of AI risk. And my impression is that law and economics has like some kind of market share among the legal profession, but like not overwhelmingly so, such that like every idea that the law and economics people think is good gets implemented. I wonder like if it makes sense to kind of make a different kind of case for these kinds of reforms that looks less law and economicsy and more something else. But law and economics is the part of the legal profession that I know the most about, so I don't actually know any examples of other ways of thinking.
Yeah, I mean, I think there's a sort of political economy argument that I think is maybe more popular on the left. That would be, one economics tends to be right coded, right? I don't think that's inherent
Yeah.
in the sort of paradigm, but I think like because of the way political coalitions are, and because of because of the way that the people who are funding a lot of the law and economics research, tend to have more sort of right-wing political goals. I don't think like my proposal here is particularly like right-wing, um, but I think a lot of the skepticism of law and economics tends to be from more progressive or liberal folks. So I think you would want framings that appeal more to them. I think this proposal is more, I think, susceptible to critiques from the right. Since I'm just like arguing for more liability for like to make life like less friendly for these big companies, right? But I think there's
Hmm.
also a lot of tech backlash on the right, so I'm not sure that like that. It's not obvious to me how that plays into the politics of this. Um, so yeah, I guess it depends whether you're asking about sort of like how to convince like fellow academics, and should there be people like writing other traditions like for providing like a different case for this. I think there's maybe scope for that. I don't know exactly what that would look like.
Hmm.
And then certainly you're going to want to use different arguments in different contexts when you're trying to persuade like a political audience.
Fair enough. I guess my next question is on the rather than on the advocacy side. A bunch of people listening to this are kind of technical researchers. What kinds of things? What kinds of technical research would be good complements to this kind of proposal? Would make it work better?
Right. So I think in particular, you want research to be able to implement various aspects of the damages formula, the punitive damages formula, and also to be able to implement the liability insurance requirements.
Hmm.
So I could see a role for model evaluations, both in deciding how much coverage, like what the coverage requirement is. So like a regulator could use a set of like dangerous capabilities evaluations to decide how much insurance you need to take out before you can deploy the model, or if it's like pre-training insurance, then to train like the next model. Um, uh, and similarly, I think insurance companies could use a slightly different set of evaluations in their underwriting process. And then in the sort of liability or punitive damages context, we need to estimate these different parameters in my liability or damages formula, right? So one thing we want to know is like how much risk should the trainer or deployer of this model have known that they were undertaking when they
Hmm.
made the key decision, right? And I could see a role for technical research trying to get a handle on sort of like reduce our uncertainty about that question. Um, there's also the question of like, well, this particular harm that was caused, like how elastic is that with the uninsurable risk? So like for every unit of risk mitigation you get, say you spend $1 million to reduce the risk of this particular harm by 20%, like how much does that reduce the uninsurable risk? That's another key parameter. Like, and how much does that do that like relative to like a generic harm that the system might have caused, right? And so, yeah, I think work on like trying to figure out how to estimate those parameters would be really useful. I have a blog post up on the EA forum that we can link to that lays out the formula and like the ways in which technical researchers can help solve these problems that you can point people to.
Sure. Yeah. And it seems like so a lot of those seem like sort of general ways in which like any AI governance effort researchers could help with. It strikes me that like trying to get a sense of like for any given failure, how much would mitigating that failure have, mitigated against like really bad catastrophic AI risks. I think like perhaps that's like a unique thing about your proposal that like researchers might not have already been thinking
Mm-hmm.
about. Great. So before we wrap up, is there anything that I didn't ask but you kind of wish that I did?
So I want to say something along the lines of like, what decisions are you trying to influence? Yeah, the question is maybe like, what decisions are you trying to influence with this, right?
Hmm. Yeah. So what decisions are you trying to influence with it?
Okay, so there's a few different ways I think you can think about like how this would influence the behavior of AI labs, right? So one scenario you might think about is, say OpenAI trains GPT-6, right? And they run it through a meter evaluation, and it shows some dangerous capabilities, and like maybe they've come up with some alignment evaluations. It's like, well, maybe this system is misaligned, right? You shouldn't deploy it, right? And the question is like,
Yep.
what do we do now, right? And there's like a sort of like trade-off or like a different set of options where like there's like cheap, dumb, easy things you could do that like wouldn't really solve the problem. You could just like run RLHF to iron out the like specific failure mode that you noticed, and like almost certainly that wouldn't solve the underlying misalignment, but it'd be really easy to do. And there's like some moderately costly thing where you like roll it back a little bit and then retrain it. And then there's some like somewhat more expensive thing where you do some adversarial training, maybe you roll it back further, right? And then there's like a really expensive thing where you say like, none of the tools we have right now are good enough. We need to like wait until we have better interpretability tools, or we like make some fundamental breakthroughs in alignment theory or whatever it is, right? And you've got different actors within the lab, sort of, some are more cautious, some are less, right? And there's a debate about like which one of these options we should take. And I want to like empower the voices for more caution, saying like, well, like maybe they're motivated primarily by like altruistic impulses or whatever, but I want to arm them with arguments saying like, even if all you care about is the bottom line, like we should do the thing that is in like produces the best expected social returns, right? Because like that's going to actually be what favors the bottom line,
Hmm.
right? And so a lot of this is like, I think you see when that a lot of these leading labs were sort of like founded with these high ideals, right? So OpenAI was founded by people really worried about AI risk, and now there's a lot of criticism of them that they're moving too fast, that they're taking too many risks, right? Sam Altman was saying, well, oh, we need to move fast, so we don't have a compute overhang, but then wants to get $7 trillion to invest in improved compute. So there seems to be something a little confusing there, and obviously there was the whole kerfuffle with the board over him being fired, right? And so we've seen that sort of these sort of internal governance mechanisms are not things we can totally rely on. I think similarly, even for a lab like Anthropic, which was founded by people, people who defected from the alignment team at OpenAI, and there were statements like, well, we're not going to try to push forward the frontier on capabilities. We just want to like have near frontier models. so we can do alignment research on them. And then Clause 3 comes out, and there's these claims that, well, it's better on all these metrics than any model that's been out there before. And so it seems like, there's very powerful financial incentives and other incentives for these companies to like build commercializable products and to push forward on capabilities. And I think even people that are like very well motivated, like, are having trouble resisting those forces. And so I think having a liability regime that sort of puts a thumb on the other side of the scale, that makes it in their sort of narrow interests to do the thing that they say they want to do, that is like in the interest of society at large, would be really valuable. And so however you want to think about, whether you think about this in terms of like competitiveness or alignment taxes, right? If we can tax misalignment effectively through this liability, I think that could be really valuable. And you don't have to think of it necessarily as being hostile to at least to everyone in these AI labs. I think some people, at least within these labs, would sort of welcome the fact that it's sort of empowering them to stand up for safety and to not just seem like, oh, this is some altruistic concern. It's actually like part of the interests of the company.
Gotcha. So I guess to wrap up, if people are interested in following your research on this or just on other topics, how should they do so?
Sure. So you can find all my papers on SSRN. Once I put them publicly, we can include a link to that. There's only one on AI so far, but I expect to do more work in the future. They can follow me on Twitter at Gabriel_Weil, Weil. And then I've got a couple posts on the EA forum, one just providing a high-level summary of the paper, and then another that I mentioned, sort of explaining how technical AI safety researchers can help implement this framework. And so I would direct people to those. Dylan Matthews also did a write-up of the paper in Vox that we can link to. I think that's about it.
Gotcha. Well, thank you for coming on the show.
Thanks. This was great.
This episode is edited by Jack Garrett, and Amber Dornay's helped with transcription. The opening and closing themes are also by Jack Garrett. Financial support for this episode was provided by the Long-Term Future Fund and Lightspeed Grants, along with patrons such as Alexei Malafeyev. To read a transcript of this episode, or to learn how to support the podcast yourself, you can visit axrp.net. Finally, if you have any feedback about this podcast, you can email me at feedback@axrp.net.